Very good morning to the e-platform of Faculty of Law, GLS University. First of all, as per the tradition of the college, we will start with the prayer.
कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं.
This national webinar will take the different facets of IP, the contemporary issues and the challenges of IP, for this different facets, the different perspective of IP will be dealt by one academician, one advocate, and an international perspective. For that, first of all, I would request our director, ma'am, to offer a formal welcome address. Ma'am is an expert member of Expert Appraisal Committee, Ministry of Environment, Forest and Climate Change, Government of India, New Delhi. Member State Appraisal Committee, Department of Environment and Forest, Government of Gujarat, Gandhinagar. Member Environment Appellate Authority, Department of Environment and Forest, Gandhinagar. Co-chair, Intellectual Property Rights, Gujarat Chamber of Commerce and Industry. Member, Legal Subcommittee of Federation of Indian Chambers of Commerce and Industry. Over to you, ma'am.
Thank you, Vidhi. It is indeed my pride and privilege to welcome all the three dignitaries to this national seminar on contemporary issues pertaining to IP. We all know that this is an age of intellectual property rights. Of course, we say that this is the age of, this is digital age, but we know that in past, if we see, there was a age of IT, there was age of IT, we talk of biotechnology, we talk of IT, and now this is an age of IP, intellectual property rights. We at Faculty of Law, GLS University, we always strive to give the best of the best to our students, and as a part of that, to sensitize them and to make them aware about the contemporary issues pertaining to the intellectual property rights. This seminar we have organized, and I welcome all of you, especially Mr. Vedant Pujari, who is from Accurus Legal, Dr. Sunanda Bharti from Delhi University, and Dr. Wen Lei from Oxford University. I welcome all of you today, and the subject is very, very, very contemporary, and especially the post-COVID. There are so many challenges because, and especially if we talk for the intellectual property rights friends, we know that every day, even in our mobile also, every day, every week, we get something new. So in this digital age, intellectual property, it's part of everywhere. When we talk for the technology, if we talk for the artificial intelligence, if we talk for the machine learning, everything around us, maybe formally we are not aware, but by one or the other way, we are governed by the IP. So how we are governed by that? What are the contemporary issues pertaining to that? And especially the COVID era challenges. Post-COVID, as we said that I am member of Environment Clearance Authority. Post-COVID and during the COVID time also, because we are amidst of the COVID. So there are so many challenges for the clearance also. So the medicines, for example, which are very essential in time of the COVID. So that was also one of the challenge for giving the clearances. The same way to give the patents and to recognize the IP rights, especially pertaining to the vaccines and the way the pharma sector has come up in amidst of the COVID in India and across the globe. So there are many challenges that we are facing today for the registration, for the patentees' rights, to the pertaining to the at times the trademarks, especially usually in IP we always talk of the post TRIPS era, but now world over now we talk of the post COVID era. So we need to club that and we need to understand the challenges. And I'm very happy to share with all of you, especially all the whosoever have joined today with us today, all the students, that please take the best of the best advantage, because all the three speakers are they are excellent in their respective fields. For example, if I talk for the Accurus Legal, they have been awarded they were awarded for their, you know that right now the startups and the innovations is also one of the very essential part for the of IP, because startups, they face innovators, they face the maximum challenges pertaining to the IP. They need the IP support. So they have been awarded by the Ministry of Commerce and Industry for the ecosystem. They have strengthened the ecosystem pertaining to the startups. We have with us Sunanda Bhatiji. She is a brilliant academician, and she's also a mediator. With we have from the Oxford University, we have Dr. Rain. She has also done a lot of research. If we read her profile, she has worked a lot of research work she has taken up pertaining to the intellectual property rights. So I wish you all the best. All the best to all the viewers and the listeners. Take the maximum advantage, and once again I welcome each one of you who have joined today, and especially all the three guests. I welcome you. Thank you. Over to Viti.
Thank you so much, ma'am. Ma'am rightly stated that this is a very need of an hour, that this discussion will be very helpful to the academicians, advocates, and the budding lawyers. Ma'am, there are more than 600 registration where there are students from various law universities, even advocates who have registered. So it would be a very helpful for them also. So here we will start with our very first session, which will be conducted by Dr. Sunanda Bhati. She is an associate professor at Delhi University. Madam is awarded her doctorate in law in 2015 for a research in legal personality of an unborn jurisprudence analysis. She has worked with into IPR for 14 years, and her subjects which she is teaching is IPR, arbitration, mediation, and conciliation. Ma'am has been a PhD guide for a number of students, and she is a certified professional mediator. So over to you, ma'am. We are eager to hear from you about the said topic.
Yes, thank you very much, Vidhi, for the introduction. And I thank the organizers, particularly Dr. Mayuri Pandya, to invite me and giving me this opportunity to interact. Uh, Now, the topic or rather the theme of this webinar was so vast that there was a lot of tussle going on in my head as to where should I begin and what topic should I choose. But I have chosen to speak on registration of trademarks and some related issues, some challenges which I see are present insofar as the registration scenario or the registration environment is concerned, right? So yes, thank you for putting up my PowerPoint presentation. Okay, uh, is it the is it the first slide? I don't see the first slide. Yeah. Okay, so registration of trademarks, that's my topic. And everyone present here is I just hope that they have some familiarity with the concept, and because I'm moving on that presumption, everyone is expected to know what registration of a trademark is, and what are its benefits, etc., etc., because it's kind of something very fundamental when it comes to IP knowledge. So I'll go very succinct here. When we talk of registration of trademarks, basically we need to revolve around, in the context of India, we need to focus primarily on Section 28 of the Trademarks Act 1999, which says that subject to other provisions of this act, the registration of a trademark shall, if valid, give to the registered proprietor of the trademark the exclusive right to use that concerned trademark in relation to the goods or services in respect of which he has gotten it registered, and of course to obtain relief in case his trademark is infringed by some person. So, slide 2, please. So, the main benefits, if you focus on slide 2, uh, yes, slide 2, please. Yes. So the two main benefits that we get upon getting the trademark registered is that you get that wonderful certificate which you can show to anyone who basically disputes your ownership of the mark, and so in that sense, registration has a strong evidentiary value. And then second important right that you get is that you get a right to sue for infringement of your trademark. That is, if anyone violates your rights in that trademark, basically by using a deceptively similar trademark in relation to the same goods that you are dealing in, or similar goods, or even dissimilar goods in goods or services in some instances, it might be taken to be a case of infringement, right? So this in fact, slide 3, please. Slide 3. This brings me to the first point that I would like to flag when it comes to the registration jurisprudence, which I see as a concern, which I see as a challenge, and which my mind kind of is it it's mind boggling as to how to overcome this challenge, basically. And what is the challenge when it comes to registration jurisprudence, or rather the trademark jurisprudence as such? This we come across this concept of deceptive similarity or likelihood of confusion, which is a very subjective phenomenon. Subjective, of course. Why? Because it depends on person to person. Now sometimes it's easy to to point out or to understand that yes, this other trademark of the defendant is deceptively similar to that of the plaintiff, but some other times it can lead to, or it can be a reason available with the plaintiff to harass the defendant and act as a trademark bully, right? So it's almost like saying that now that my trademark is registered and big, you dare not choose a trademark that is even remotely closer to or similar to that of mine, and which results in objecting to the defendant's trademark by the plaintiff for no sort of reasonable reason, if I'm making sense there, right? And we often see the registry, at least in India, succumbing to, in fact, across the globe, at least what to the research that I have gone through and I have undertaken clearly hints at this, that the registry, basically they end up succumbing to the might of the big players, and the courts also do the same. They follow suit while deciding the concept of deceptive similarity. And I have two examples here. Now they are not Indian examples, but they still are very interesting. Slide 4, please. One is, yes, slide 4. Yes, slide 4. Who is she? She, of course, is yes. I hope you can. Everybody is in a position to identify the logo. That's the Starbucks logo, and yes, this is not an Indian case, which goes to underscore that the problem of defining what is deceptive is perhaps universal. This green lady is actually a mermaid with two tails, right? And the name that this mermaid has is Siren. So she is universally recognized as Siren, right? And just to deal with, I'm digressing a bit here, but I feel that it would be relevant to understand the story behind this logo in order to understand the point that I would be making towards the end. Seattle is the hometown of Starbucks. Now, Seattle is a port city having strong connections with sea navigation and coffee and trade basically, and coffee is still traded through its waters. And hence this device trademark, if you just focus on this device trademark of Siren, it is actually an excellent example of smart creativity if you link it with this story. Now, the problem is that this Siren is popular, okay? Because if you look at slide 5, please. Yeah, slide 5. Now, Mountains and Mermaids is another brand trading through Siren. It also has this mermaid, and you can see the image for comparison. So now these two proprietors, Starbucks and this owner of Mountains and Mermaids, they are fighting a battle over this mermaid, right? And when it comes to who is Mountains and Mermaids, as in who is the owner, who are they, where are they placed? It's a very small Alaskan company, so it's almost a non-entity as compared to the mighty Starbucks. And this company, Mountains and Mermaids, basically deals with apparel. Now it's diversifying into coffee also, and it uses the expression Siren's Brew. If you focus on the middle logo, you'll see that it uses this expression Siren's Brew. It has proposed to use Siren's Brew for its products, including coffee mugs and basically coffee, right? And Starbucks had initially applied for a trademark Siren's Blend for its coffee products. Now, what Starbucks wants is it wants basically the U.S. Patent and Trademark Office, USPTO, to reject the application of Mountains and Mermaids on the ground of confusing similarity. And whether they are confusing or not, it's there for you to see. I've deliberately not placed them side by side because we are not supposed to do that. We are not supposed to place the two competing marks side by side and then do a microscopic comparison. That is what the law says, right? So I've not done that. But even if when we see them one after the other, at least I do not see any confusion or any confusing similarity occurring. But then what Starbucks is claiming is their main objection is on the usage of the word siren and the accompanying depiction of this siren. Okay. And in fact, they maintain that Starbucks has invested over the years since 1971, ever since they started, they have invested so much in creating that association between siren and coffee, that anything related with siren, uh, basically, people are likely to associate. That is what their claim is, that people are likely to associate it with them if it has anything to do with siren. Now, whether it is confusing or not, I leave it to you. For me, it is not confusing. It is just an example of trademark bullying, and so this is something second point which I wanted to flag. Another example I have, which I'll just go over it in brief, which was very popular, and that is slide 6, Apple versus Pear controversy, right? Apple decided to take legal action against this company called Prepare, and this was sometime in 2020, I think August 2020. So it's a fairly recent case, and it is not one of its kind. Apple is famous, or rather infamous, of doing this. Right, and they maintain that this pear-shaped logo was very similar to their own logo. That is what Apple maintained. Although Prepare, it is to be noted, has nothing to do with technology. It is basically a mobile app that offers healthy recipes and a digital grocery that goes along with those recipes. Now, Prepare, for reasons of its own, and I think thankfully it stood its ground. It refuses to buckle down. It refused to buckle down, and it when this controversy came to it started gaining some traction in the relevant circles. What Apple did is Apple offered to negotiate, and then we heard that that companies reached an agreement whereby Apple allowed Prepare to use the fruit logo, and albeit with a subtle change. Next slide, please. Slide 7. So this is the change, and this again, I think, is a classic example of trademark bullying. Uh, okay, the point being that sometimes this aspect of, because I was dealing with confusing similarity, deceptive similarity, it being subjective. And the point is that sometimes this aspect of confusing similarity is taken to the limit, and it happens more, or it happens more aggressively when the trademark is registered, plaintiff's trademark is registered and reputed on top of that, right? And how to deal with these pressures, and this whole big notion, whole big point of it being subjective, is something that I don't think law as such would be able to overcome unless and until we make use of technology. Perhaps I'm not sure how we are going to do it. It remains a challenge in my opinion. And then, yes, another point. So, second point that I want to flag, slide 8, is territoriality and trademarks. And if we link this point with global markets, because presently markets they cease to be local, they are more global. Everything is being supplied everywhere else, and everything is being consumed, even if it is produced locally. Of course it is being consumed everywhere, right? So, and while this how is this going to be blended, or this going to be aligned and understood with the fact, essential fact that remains, that trademark rights are territorial in nature. That means trademarks would be, uh, if we consider the Indian scenario, trademark would be protected in India, say under the Trademarks Act 1999, only when if it is only if it is used in India, either in the registered or the unregistered form. And this protection would be available only in India. That means if I want to operate in France and want my trademark to be protected in France, I need to fulfill the legal requirements there, the trademark law requirements there, and only then it would be protected. So they are territorial in nature, barring a few exceptions. Okay. Now, how this principle of territoriality plays out in the real trade, given the global reach of the internet, which has made cross-country availability of goods possible, is something that needs to be understood and taken care of, and perhaps even accepted by the brands now, because due to the global nature of the internet, products that are offered for sale online can be viewed by a party stationed anywhere in the world. Likewise, as I said, from the seller's perspective, anyone present anywhere in the world, you know who is who is connected to this net, who is connected to this grid, has the potential of supplying everywhere. So this makes the registration environment very tense and challenging. Why tense and challenging? Because where there are multiple owners of the same trademark in different territories, when one owner, say owner one, meant to supply only to country one, tries to fulfill a customer demand made in country two, that is a different territory, a question arises as to whether it will amount to trademark infringement or not, or whether it should amount to trademark infringement. So, this is a very sort of an unsettled position as of now, as I see it, and it remains a formidable challenge to take care of. Uh, okay. Now let's see some other trends that are there with the registry. uh, there are a couple of points that I've jotted down on the slide, and I would want to briefly touch upon each. So one is creativity and trademarks. This is just to highlight that what all is accepted by the registry, basically when it comes to the nature of trademarks, or how the looks of the trademark. And here we see that the registry is displays a very it appears to be big hearted, right? Because all sorts of creative trademarks are accepted. We have slide 10, slide 10 please. We have Trebo. Trebo is so this is I think in my opinion a very very creative mark, because it is um, if you take a guess on what this trademark would mean, it is actually Bodhi tree, which is a Bodhi tree, reverse of this actually. So, and I love the thoughts behind using this trademark. As the founders say, in many ways, trees were the earliest forms of budget hotels, offering shelter to travelers without discriminating between the rich and the poor. This is a creative trademark. Then I think one of the masterpiece of creativity is the Unilever logo. Unilever logo, I think, is truly amazing, because it is, in fact, to me, it is one of the most beautiful pieces of symbolism that I have come across. And so, such trademarks are accepted. And then we have another category, which is, you know, catching up insofar as the trend goes. Slide 12, please. Names and trademarks. Can we register names as trademarks? And yes, why not? We can get them registered. We have, when it comes to the old school examples, we have Chalaram Parker, which is Chelpark, basically. Those who have used a fountain pen in their lives would know that yes, Chelpark used to be an ink, and it is a combination of Chelaram and Parker when they decided to basically uh, sort of form a joint venture. And then Messi is the latest example in line. Messi, next slide, please. So names are accepted as trademarks. So this is the trademark Messi, which and in fact this the footballer had to fight tooth and nail to get this trademark registered in his name, because it was being vehemently opposed by another trademark, Massi, Massi. So nonetheless, we have names as trademarks, and they are widely being accepted. And then something new. Slide 14, please. Yes, we have humor and trademarks, and this also is a field where at least the Indian trademark registry is showing a very big heart, and accepting even those trademarks that sort of tend to tread on a very thin line between hurting somebody's sensibilities and being outrightly humorous. So this is one trademark that is registered. Ye big gayi hai government. That is this. The government is sold out. Right? It is sold, not sold out. It's sold. It has sold itself. So yeah, and then next slide, please. We have a couple of few other very interesting examples. So yes, we have John Doe as a trademark. We have John Doe as a trademark. We have Hitler as a trademark, right? And yeah, so when it comes to humor, even humorous marks such marks are also being accepted, which is okay, which is good in a way that nothing, if nothing bad is resulting from it, so everything is good. But then at the same time, uh, next slide, please. We have one very curious example of this mark. This is the Make in India mark. Now, how this Make in India mark is a registered trademark is a mystery to me, at least, because one fundamental thing is that a trademark has to be in relation to some goods or services. You need to supply the market with some goods or services, right? It cannot exist in vacuum. That is one of the fundamental foundational aspects of trademark law, and I think across the globe, right? But this trademark is nothing is being supplied. It is owned by the department, DIPP, and it is just put on various websites, various papers, and various goods, just like that. Nothing is actually being made or supplied under this this mark. And if you focus uh, on it a bit in detail, you'll realize that the function that this mark ends up performing is that of a certification mark, because it sort of tries to put across the point that this product on which the mark is placed is made in India. So it has been manufactured in India, right? And it is of a certain quality, hence, right? So but it is not registered as a certification mark. It's registered as a simple device mark under the Trademarks Act. Now, what such examples make you wonder as to what is happening with the registry or at the registry, at least in India. uh, Next slide, please. Another thing that boggles me is and this is like ever since I started my association with trademark law as such, this has bothered me, and that is dual protection in trademark. So Darjeeling tea, uh, when this GI, we were not into the GI regime. Before that, Darjeeling was protected and as a certification mark. So that was accepted. But ever since the GI Act came into force, that is 15th of September 2003 to be precise, right? It became the first geographical indication to get protection under the GI Act. But it continues to be a certification mark as well, or at least that is what their website says. I could not find the registration certificate as such. But then it if it is true, it is a registered GI as well as a certification mark, which is a curious situation, because all the time we maintain, and that is how we study, that dual protection is not available under intellectual property. You cannot get your intellectual property protected under two streams. And you know so it's that. So this is a very confusing or rather curious situation for me, which again makes me wonder as to what exactly is the registry doing. And then we have slide 18, please. And I think that's the second last slide. I'll be very quick with it. Non-conventional marks and registration. So slowly and steadily, yes, India is opening up to non-conventional marks, particularly smell marks. Uh, because as such, our act does not in so many words, in that black letter form, does not recognize smell and taste and position marks as trademarks. But we are opening up to smell marks, at least in India. And we have a couple of examples there, that they are there on the slide. But again, it makes me wonder, and I think it is kind of a take it to be a challenge sort of a thing, because the requirement of graphical representation is being fulfilled here. Yes, you do have musical notations, so hence all the requirements uh, of when a mark can be a trademark under the Trademarks Act 1999, they are fulfilled. But what is curious is whether noise can be equated with sound here, because the sound of, or rather I would say noise of motorcycle starting, the noise of motorcycle shutting down, these are noises. Are they sounds? uh, Similarly, like recently, if I remember correctly, the sound of a can opening, a can of soda opening, and the accompanying fizz that goes along with it, it was refused as a trademark by the European Union IPO. So patent office of Europe, it refused to take that as a valid trademark, because of its generic nature, because they said see, there is nothing distinctive about it. But look at the kind of examples that we have in India. And so where noise has been put at par with sound and given trademark registration. And this wonderful research is not mine. I've taken help from a wonderful friend who has been acknowledged duly. But meanwhile, what we need to consider is what next. There was one, we are operating on extremes. On one, to begin with, we were like No, absolutely not. When it comes to smell, taste, and other such non-conventional marks, our law says no, we cannot register such marks as trademarks, and so we were denying them registration altogether. Now, when we are opening to the extent that everything is being accepted uh, as registrable, right? So what next? Sound of a pressure cooker whistle, sound of a car, um, this car door, car engine igniting. What next? What is next in line? So uh, this is again a disturbing trend that I wanted to flag. And with that, I come to the last slide, slide 19, please. So much is being done by the registry and by law and by courts, while I feel that an important aspect is completely being overlooked, and it is a challenge with the legislature, as well as the judiciary, I think. Because you cannot be for sure, as in you cannot be assured as to where from that initiative would come. Okay, and that is in relation to discrimination and trademark. Discriminatory trademarks still rule the advertising world. Okay, and what I submit here is that section 9 clause 2 of the Indian Trademarks Act, which gives out the absolute grounds for refusal of registration, they say that okay, scandalous and obscene matter cannot be registered, a matter that is likely to hurt religious sentiments cannot be registered. Another ground should be added there, and that is that a mark shall not be registered as a trademark if it is discriminatory in nature and is violative of the fundamental rights enshrined in Article 15 of the Indian Constitution. So, for me, Article 15 is basically just to uh, relate this to what I'm saying. It basically says that the state shall not discriminate against any citizen only on the grounds of race, caste, sex, place of birth, etc., etc. And the overall panorama surrounding skin color, because that is the example that I've taken, Fair and Lovely. So the overall situation and the scene surrounding skin color preferences in India is sufficient to indicate that darker skin color results in discrimination. And given this scenario, I think it was an excellent decision on part of HUL, Hindustan Unilever, to drop fair from their Fair and Lovely trademark. And that is how it should be. But 9.2 should legally, as in the statute, it should be included as a prohibition. That's my last submission for today. Last slide, please. Next slide. Yeah. So I just hope that you enjoyed this, and that it was worth your time. I would have loved to interact with you had this happened in person, but since we are online, I would love to connect with each one of you on LinkedIn. Thank you very much for your patience.
Thank you very much, ma'am. Thank you so much. Ma'am, in a very simplified manner, uh, ma'am, in a very simplified manner, explain about the trademark, the registration, deceptive similars by giving various live example, so that the viewers can very well connect to the topic. Uh, Very well explain about what can be registered and what cannot be registered. So thank you so much, ma'am. And we will have an open floor for this session also, first session at the end. So over to the second session, where uh, we will have Mr. Vedant Pujari, sir. Sir is a managing partner at Across Legal. It's an intellectual property, corporate and commercial practice firm. A firm is established by the group of IP professionals and corporate lawyers with an average experience over last 15 years. They assist clients in all field of intellectual property, including patent, trademark, copyright, designs, plant variety protection, geographical indication, from its development to its monetization. Sir pursued his law from ILS Pune. He has past served as a head of a trademark department at Lexoris IP practice. And Sir has a rich experience in providing corporate commercial advisory on the commercial contracts, corporate transactional matters, incorporation of companies, and their maintenance and statutory compliances. Sir is also involved in conducting various workshops, lecture series, and seminars to educate and train the in-house personals of the company, institutions, government and semi-government bodies towards aspect of creation, management, and commercialization of IP. Sir, we welcome you and over to you, sir.
Thank you very much, Dr. Shah. Thank you, Dr. Mayuri Pandya, Ms. Forum Pandya, and my co-speakers, eminent co-speakers, Dr. Bharti and Dr. Van. First of all, let me put this on record that I am not having any kind of a presentation, but I'm going to tell you some key aspects or key challenges that we usually face in enforcing an intellectual property right in India, and not those challenges that are of today or of digital age, but also some of the challenges that India has very nicely overcome. Now, I started my practice sometime in 2003, and at that time, intellectual property was completely unheard of. So there were very few law firms and very few companies in India who actually valued intellectual property and went for the registration. So it was just the starting at that time, and therefore, copying of intellectual property, or as we say in a legal language, infringement of intellectual property, was not something that was looked at as a serious offense. So at that point of time, it all grew from there. Now, IP infringement is nothing. It's nothing new. It's been going on for many years. Um, the evolution of legal system to safeguard the rights of an intellectual property holder took a little time to evolve. I'm not talking about the developed countries, but usually developing countries like India with many challenges. And today, as we stand, I must say that India has evolved to a very good extent in terms of protecting intellectual property. The courts have become very pro in giving interim injunctions to the rights holder. Now, I'm going to tell you a few instances that I came across in my past 15-16 years of practice, and those will also let you know what the challenges are. Now, in 2003, when I was a young professional, I wanted to accompany my senior on raids, and we went there. This was a place in somewhere in Delhi, and we first went to the police. Now, as you all know, that intellectual property enforcement happens in two ways. One is through the police route, as we say, and the other one is through the court route, where you file IP infringement suits. Now, when we went to the police and we said that there is this was an international brand, they wanted to conduct a criminal raid or a raid on a company or on a seller of their goods somewhere in central Delhi. I'm not going to give you details of the brands, which I cannot. But when we went to the police and we said, look, this is a validly registered copyright. This is their trademark certificate. They have a complete right on, so please accompany us and take us through, along with us, please come and conduct the raid with us, because of course we have to involve the police in that raid. It took us about 3.5 days for the police to know, and this I'm talking about 2003, for the police to actually understand whether they can take cognizance of this matter, whether they really have this. They are well within their power to take cognizance of this matter and accompany us. So this was the time when, from where India started, way before that, but I'm talking about my experience. And from here, recently, very recently, I have taken about 1.5 days, one full day lecture series for the Rajasthan police. So from there, where police and the authorities were not aware of IP, now they are willing to conduct seminars, and they want to understand what intellectual property is. So things have improved. They want to understand how they can help, but there are still some challenges that we must address, and not everything is a rosy picture here. Now, I'll tell you one case that we recently had. There was a client of mine. They manufactured um, parts of vehicles after sales. That was basically for motorcycles. Now, one of the colleagues in his company, my client's company, he actually stole the spare parts, and he left the company, and he started his own company. Actually, he did not leave. He started his own company while he was employed here, and my client had all the registered designs with him. Now, when he blatantly copied these designs, and he started a new company, and that was a proprietorship, and he actually went ahead and put those spare parts or parts on Amazon and Flipkart for sale. My client, the colleague who my client came to know about this, and he came to us. The first thing that we suggested is, write to Amazon, write to Flipkart, and ask them to remove those online sales, because unfortunately, Amazon and Flipkart have a very standard way of allowing a seller on their website. They don't go through. They, of course, they ask you for some certificates, but there are many times they are not aware, or they don't go through the actual facts, whether these goods, or the IP in those goods belong to this particular person or not. And that is the reason why, you will, even if all of us keep shopping from Amazon and Flipkart, and all of us must have come across sometimes that you receive goods that are not actually the ones that you saw on the website. At least once it must have happened, or you must have received some substandard goods thinking that you are actually ordering from a brand. Now, this is what happened. Now, we wrote to Amazon and we wrote to Flipkart, and it took them about, Amazon did delist the entries, but it took them about 1.5 months before they delisted the entries. Now, I'm not saying Amazon is the procedure inside Amazon is bad or good. I'm just stating how difficult it sometimes it becomes. Now, within those 1 or 2 months, there were sales that happens. This person, we filed a police case. We filed an FIR against him. One was for theft. The other one, we had to actually send him a legal notice, and then we were going ahead and filing. This case is basically underway, so I'm not going to reveal too much details. But when it comes to infringement in today's world, and Amazon, Flipkart is just maybe one of those websites where you can sell these goods, but there are many of them. There are Mintras, there are Ajios of the day, where everybody wants to make money, and they don't really understand to what extent should they go to actually protect, or to understand what they are putting on their website is actually an infringing product or not. Now, can you hold Amazon and Flipkart responsible for hosting infringing products? No, we cannot. So they have a very detailed agreement, in which if you tell them, they'll say, okay, we are taking efforts to remove or delist this infringing product, but you'll have to really tell us or show us that this is infringing product. And also, we'll take our procedures. There are internal procedures through which they do this. So in this digital world, it becomes extremely difficult okay, you can go to one website or the other website, but you may probably not be able to capture all the websites that list these products. Recently, the same client found out that this gentleman was again selling through one of those websites, and so we had to inform that website. uh, we faced a similar challenge when it came to one of our fashion brands that we work for. The company, we had filed a trademark and got a registration in China, and they have a very huge, large e-commerce website, Chinese e-commerce website. I think it's JD.com, and we tracked down the infringing products that were being sold through that website. Now, China is a huge market, and when it comes to fashion, China is one of the largest fashion consumers product. They are very pro fashion products, and my client makes shoes and sunglasses, and we tried to stop that, but it didn't really happen because JD.com was not interested. They were more interested in selling their products in the infringing products, and they really one didn't pay too much heed on the fact that the gentleman, it was a real product. Basically what has happened was that my client had licensed their trademark to somebody in China. My client also had a registration in China, and because the other party, the licensee, did not pay the royalty fees, my client had cancelled the registration, cancelled the license, and even then the other party or the licensee continued to sell these products, and they are still there on JD.com, and they're selling it. So these are some of the practical challenges. If you're doing, my client has invested lot of number of years in this, and they have also put a lot of money in making their mark to where it is today. But they're finding it very difficult to stop the infringement of their mark. Now, when it comes to digital age, you find one more challenge. One of the challenges that we face is about the servers. Now, you don't really know where a website or the server is, but yes, in India you can make, suppose if GoDaddy has given the registration or the domain name, then we can tell GoDaddy or make GoDaddy a party, and then they can stop the domain name from India. But then in other countries they would be selling. So these are some of the challenges when it comes to digital age and enforcement. One of the things, the next story I must tell you, this was one of the cases where we found it difficult because of the online selling of the products. Now let's come to the offline, how it operates. Now recently there is a pharmaceutical company in Mumbai. They make baby products, and this was about 3 years back when they found their marketing team informed them that these baby products are being sold illegally through the products were correct, but the products were legal. I mean, they were not infringing products. This was actually parallel import. Now, what this other person was doing was, my client had an exclusive license from a company who in UK or Italy, I think somewhere, who makes this baby product to be sold in India. And there was this import that was happening apart from this through some Dubai route or somewhere. Now, my client said that this, even though it is the product are from the parent company or are genuine, but they are not selling it legally here because they are not supposed to sell it. The trademark and the product exclusive license for India was with my client. Now, when we went to the police and we told them that this is an infringement because my client owns that trademark by way of license in India, the police said, okay, what are we going to tell them? Like, how should we go and how should we conduct the raid there? Because the products are not products are genuine. They are not producing any kind of a substandard product. So, which was shocking because we even if they are not producing substandard products or the products are genuine, they are still not providing those products to the public under a valid trademark, which did not belong to them. So it took us a lot of time for us to educate the enforcement authorities, the government enforcement authorities, to conduct these raids with us. We eventually got the raids conducted. Now, the second problem in such raids that happens is that And please don't take me otherwise, but it is a very live practical problem that we face. Is these products were sold at multiple in multiple shops at multiple places. Now let's say if these products were sold in Delhi, there's a place called Karol Bagh, or say Gafar Market and X1 places. They're very close, about in a area of about 3 to 4 kilometers, but they were sold at various places. Now if we conduct raid at one of the shops, then either that shop owner will let the other parties know that there is a raid on his shop, and so we will so the other parties or the other infringers will quickly take off their products from their shelves and probably hide it somewhere. Our raids will be unsuccessful, because unless we confiscate the goods, there is nothing we have against them. So we had to conduct simultaneous raids. Now when it comes to simultaneous raids, which means that our teams are always available, but the police team had to be split into 2 or 3 groups, and then we had to conduct that raids. um, I'm getting into a risk of saying something that, but it's not that everywhere it happens. But I will still say this: many times there is information that is leaked through the police station as well, through these to these parties. We have to be very careful how much information does the police have when it comes to conducting the raids. Now, not all. I'm not talking about corruption or anything here, or I'm not blaming any authority for that matter, but sharing my practical challenges that sometimes we have. So when we go to the police, we have to be careful on how much information we reveal, but we still have to reveal ample information for them to take care of their authorities and take care of their cognizance, that they will say, okay, yes, we are going to go with you. So most of these criminal enforcements, when it comes to raids, this is a major problem, to conduct simultaneous raids, or the keeping the information so tight that only very few people know about where the raid is going to happen. Otherwise you will not find any goods. Now this is an organized market. IP infringers are organized people, pretty organized. Um, when it comes to IP infringement, it is there are some sections of people who only know that. You know, we conducted this particular raid of baby products, and there was an arrest that happened of the infringer. And later on, when we were talking with that infringer, the police was talking with that infringer in the police station, and he was a 65-year-old man. And now somewhere we feel bad that, at this age he has to go through all this, but an offense is an offense. So he himself said that, look, I don't care, I just know how to sell these products, and that is what I'm going to do once I come out of the jail, or if I am on bail. So that is the mindset that we are tackling with. Now they don't care about this thing, but the companies have to, time and again, the rights holder have to time and again conduct these raids to create a dent in the market, and let other people or infringers know that they are going to take serious steps when it comes to infringing of their products. Now uh, not all companies can do that. Not There are companies who say, okay, let it happen. What is the revenue loss? If the revenue loss is bearable, they may take decisions of not conducting the raids, because probably the cost of conducting the raid may be more than what they are losing. So it totally depends on the rights holder, but this is one of the challenges that we every time we face. Recently, there was a case, a new client that came to us. There is a brand name of an oil brand. It's an edible oil brand, which belongs to Adani Wilmar, and they had to actually conduct the raid in one of the remote areas in Punjab. Now, the problem that we face here, the challenge that we face here when we take up such matters is the people who are manufacturing these infringing products or using the trademark or similar deceptively similar trademark in those areas are very well established, very well known people in those small villages or small areas. They are very influential people, and even though India is a vast country. So for people who in this seminar, for the people who have joined us from outside India, should also know that we are a vast country. We have a lot of various, um, you know. How can I put this? We have very diverse culture, and small villages and places where people don't really are not really aware of what a high court order may uh, bring for them if they don't comply with it. Now, sometimes even if this oil brand, the rights holder, actually had registration certificate of their trademark, they had every absolutely unblemished right on their oil and the brand itself. But and they had a restraining order, they had a injunction, permanent injunction against this person. But even though that person was manufacturing this particular oil in this small village, when we went to we actually did not go there to because I think the matter did not come through or whatever. But when we were doing the initial investigation, we found out that the person who was manufacturing was virtually everybody knew him, and if we go to the police in that area, it was there was all likelihood that the police will inform him that this is going to happen. So we had to actually go to a higher authority, and then we were planning to go to a higher authority, and then we would have taken the cops from here to that particular place. So these are the practical issues that most of the IP enforcers, and when it comes to, I'm not talking about the court enforcement because they are infringement cases that we file, and then we get the interim injunction or the permanent injunction. We sometimes get into mediation, but I'm just talking about the enforcement on the floor. Most of the lawyers these days who are on the IP, who want to practice IP, don't really get into this real life enforcement. But I would suggest that to all the students that at least start your practice with trial court, and also get into some kind of action that happens on the floor when it comes to IP. So I'll just, do I have Dr. Vidhi? Do I have time? Do I have more time?
Uh, yes, sir. Yes, sir. You can
Okay, so
proceed for more 10, 15 minutes.
okay, so I'll just take another 5-10 minutes. Now, there was one more case that we recently handled, and this was more to do with food adulteration versus um, IP infringement. Now, when we were, there is a, you will be amazed to know this, but there is a huge confusion when people say, and this was one of the matters that came through us when when we were training the Rajasthan Police Academy on IP and on how to conduct IP infringement cases, how to deal with it. And there's a small um, uh, oil manufacturing. I think it's ghee. Ghee is what do you call it in English? So they manufactured, it's butter basically. They manufactured butter, and this company, this small entity, actually used an infringing trademark and made a substandard um, uh, butter or ghee, and that's what they were selling. Now, when the police went to that particular, with the help of my another lawyer who's a friend of mine, and when they went to his premise, they could not actually, they did not book him under trademarks infringement, they or copyright infringement for that matter, but they booked him under Food Adulteration Act. Now, this was strange because why Food Adulteration Act? It is not one of those very strong laws. Unfortunately, it is a strong law, but not as strong as, or does not have strong consequences as we have in IP laws. And the police informed me during the seminar that that is what was the most suitable for us. Now, when machineries come together, it is not always the law that operates. It is most of the times the convenience of the people that operates. So, to all the lawyers or people who are coming into IP, you should also know how to practically approach a police station or a court, and keeping the interest of your client intact, because the rights holder interest has to be kept intact. But at the same time, you have to have the skill to bring two or three machineries together and conduct a successful raid. Now, once the raid is conducted, the court proceeding starts, the session courts and all those things. Most of the clients are not interested in taking things further, so these people get bail, because most of the client don't want to pursue the cases further. They just wanted to make a dent in the market and let people know that they are going to take things seriously, and then they go, and then people, the alleged infringers or infringers, get a bail, and then they probably start the same thing all over again. So I would like to conclude here. These were few of the experiences and the challenges, the real life challenges that we face every day. There are challenges as far as the court proceedings are concerned, but I am very happy to share with you that we now have judges. We now have an IP court that is going to soon come up. IPAB is now so there is a very good chance that India will be one of those very pro country when it comes to protection of the rights holder. Recently, I think US has also listed India in one of those lists where it considers India as a low a jurisdiction for low IP enforcement mechanism. But I strongly don't believe that. We have a very strong mechanism now. The cops are in Delhi specifically, or in places where in large metro cities at least, and in large cities, the cops understand what IP is. They are very willing to cooperate with us and come with us for conducting the raids. So things are slowly changing. There still are challenges, but everywhere, all over the world, if there is a law, there will be a person who will break it, and there will be challenges, and the law and the legal machinery have to keep on evolving every day. As the technology also becomes sharper, we have to make our legal system sharper, and people like us, we are always standing there to ensure that the rights holder are always their trademark or their patent, their copyright, for that matter, is not infringed by anybody. And if it is infringed, then we take the necessary actions as per the law. So thank you very much. I once again thank you for inviting me to speak here. Usually I come up with a presentation, but this time I was unable to make a presentation. But I hope I was able to do justice to the time that I was given. Thank you.
Thank you very much. Thank you very much, sir. Sir, very well explained about the IP law, how it evolved, and how the courts have become proactive in dealing with the IP matters. Sir, with your live examples which you have dealt with, the students and the viewers are really motivated. And when you stated that the IP courts are coming, the budding lawyers, I'm sure they will be more interested, and they will go further in dealing with the IP matters, going into the litigations and non-litigation side of IP. So thank you very much, sir. Now the third session that which we will start will be of uh, Dr. Wen. Wen is a departmental lecturer in intellectual property law at the Faculty of Law, Oxford University, UK. Prior to joining Oxford, she taught IP law at Warwick and Durham. Wen pursued her LLB at Ho Chi Minh University, Vietnam, and completed her LLM from Bangor University, Wales, where she also granted the Bangor University Fellowship to pursue her PhD in IP law. During the writing of Wen N's doctoral thesis, she was granted a research scholarship at at the prestigious Max Planck Institute for Innovation and Competition in 2016 and 17. In addition, she is a recipient of a Eric Sunderland IP Law Travel Scholarship in 2013, awarded by Welsh Library Company. Van's area of expertise includes pharmaceutical patents, TRIPS flexibility, compulsory licensing, and access to medicine. She is highly interested in public policy. She is an author of a book, Compulsory Patent Licensing and Access to Medicine, which is just published in 2021. She is going to speak on the topic of are IPRs and patent the real barriers at COVID-19 vaccine supply? Over to you, ma'am.
Thank you very much for your warm introduction and thanks for inviting me to the webinar. I am going to share my PowerPoint slide and please let me know whether you can see it clearly or not. Okay, just give me 1 second. Okay. I don't think I can share my screen so far, isn't it?
No, we can't. We can't see your screen.
Like I had told when at the downstairs there's a share button. From there you have to do it. You have to keep it on your desktop.
Yes. Okay. So I have to keep it on my desktop.
Yeah.
Yeah, sorry.
Open the file, minimize it, and then you can share it from the below.
Okay. And share screen, isn't it?
Yeah.
Can you see it
Yes.
now?
Yeah. Yes.
Okay. So today we are going to discuss a very burning question. That is, are intellectual property rights the barriers to COVID-19 vaccines production and distribution? Before going into details, just have a look at the past 2 years. I would like to say that my presentation today is based on my article that you can see. So if anyone interested in reading my article, please get in touch. So we know that at the end of 2019, the WHO was informed of a pneumonia cases in China, and later on it was named as the COVID-19. And in March 2020, COVID-19 was declared as a global pandemic. And in less than a year, we have the vaccines filed in November 2020, and by December this year, we already have 25 vaccines approved in at least one jurisdiction. However, there have been new challenges arising, mostly surrounding the global distribution and access to these vaccines, particular for low and middle income countries like Vietnam, the country where I am originally from. And intellectual property rights have been viewed as barriers to global vaccine production and distribution. So therefore, in October 2020, India and South Africa proposed a temporary waiver of IP rights, and the waivers included on intellectual property rights, patent, copyrights, industrial designs, and even the trade secret. And the waiver aims at preventing, containing, or treating COVID until the widespread vaccination is in play globally, and the majority of the world's population has developed immunity. This proposal has a very ambitious scope, and is targeted a wide range of medical products, including vaccines and medicines, or even to scaling up of research, development, manufacturing, and supply of medical products essential to to combat the COVID-19. And unsurprisingly, this proposal clearly divided the world. However, it's gained a momentum when the US has expressed its support for the proposal in May 2021 this year. And therefore, later the waiver was revised, and in May this year, it also released the revised proposal. And there are three takeaways of the revised proposal that I would like to highlight. So first of all, the revised proposal provides additional clarity as to the scope of the original proposal. And the scope this time encompasses health products and technologies, including diagnostics, therapeutics, vaccines, medical device, personal protective equipment, their materials or components, their methods and means of manufacture for the prevention, treatment, or containing of the COVID-19. And similar to the original proposal, the scope of this revised waiver applies to the implementation, application, enforcement of on-TRIPS provision regarding copyright, industrial designs, patents, and trade secret. The second point is, in contrast with the original proposal, the revised proposal added a sentence which recognizes the the need to preserve in sentence for research and innovation, and these should be balanced with the public health interest. And finally, the revised proposal provide us the waiver shall be enforced for at least 3 years, and it will be subject to annual review by the General Council. And the WTO General Council could be the one who decide whether the exceptional circumstances leading to the waiver stop, if such circumstances exist. So the council will decide a date to terminate the waiver. So to me, it seems that the proposal is built on the premise that once we remove the patent system and other form of intellectual property rights, COVID-19 vaccine will be made cheaper and quicker. That's not true in my view, and let me explain you why. The problem with the proposal is, first of all, the scope of the health and health products and technologies remain unclear because first of all, the proposal doesn't provide any conclusive list, and it's very difficult for us to separate which technologies related to COVID and which technologies are not, because we kind of know that for the same products, it can be treated for different diseases, and it can be applied in different industry. And we cannot have a box to put, okay, to claim here is on the health products and the technologies, and here those other things that are subject to the waiver proposal. And another thing we need to keep in mind is the U.S. ambassador statement in May make it very clear that the U.S. support for a temporary waiver for COVID vaccines only, not other health products and technologies. So that is something that we need to take in mind. And the last thing is WTO members can choose whether or not they will waive the IP protection in relation to COVID-19. And the waiver will need to go through domestic implementation. So I can imagine the situation where the one product or one technology can be subject to different type of law in different countries, and that will create problems regarding patent activities and might lead to patent litigation in the different countries. So in my view, the IP waiver is not a solution to the the inaccessibility to vaccine. The reason for it is, first of all, the vaccine manufacturing is a very complex and sophisticated process, and vaccines are biological products. They are sensitive to heat and they are susceptible to microbial contamination. So if in small molecule drugs would have generics, there is nothing called generic vaccines, because even the simplest of biologicals must go through clinical trials, and on the vaccine needs to go through human studies and bear related costs in order to be registered. And therefore vaccines are subject to wide variation even between batches. And for complex vaccines like the COVID-19, hundreds of quality control checks are required to approve for each batch. So to underscore the difficulties of producing vaccines, even by experienced third parties, I can give you an example of a company like Emergent, and they have to discard up to million Johnson and Johnson doses and a number of AstraZeneca doses. And vaccine manufacture is also one of the reasons explain why AstraZeneca has some issue with the production at the beginning of the vaccine manufacture, because they are not expert in a vaccine manufacturing. And the biological nature of vaccines makes their development, production, and regulation very different from normal medicines. So if generic drugs can demonstrate the bioequivalence to the patented products, this is not an option for vaccines, because the second generation vaccine in this case are considered as a new vaccine to the market from the regulatory point of view. So we can see the price of some generic medicines can fall by more than 80% of their first generation's equivalents. Similar reductions for the second generation vaccines are unlikely to happen unless we address the fundamental drivers of cost. And another reason I think why IP is not a solution, because waiving IP protection cannot help us to have more expertise in the vaccine industries. the manufacturing vaccine process is very labor intensive. And I can give you example. So the Swiss government in this year, I think in July, they had to step in to help a Swiss company called Lonza to recruit staff to scale up Moderna vaccine. And they couldn't find enough qualified employees. They can only find 25 skilled experts, whereas they aim to recruit 75. So that's another challenge that I don't see that the IP waiver can help to solve. Another thing is vaccine manufacture requires a huge amount of input material. As you can see from the slide, in order to manufacture Pfizer vaccine, we need to have 280 components from 86 suppliers from 19 countries. And I cannot imagine how the IP waiver will help to reduce those amount of input material. And the interdependence between all the suppliers that need to be strengthened in order to ensure the vaccine manufacture happens smoothly, because at the lack of one of the input materials can force the manufacturers to discard the whole batch. So that is something we have to take into account. And the export restriction of the U.S. and India doesn't help the suppliers to have the components, to have the input material that they need to ensure the vaccine manufacture. Another weakness of the IP waiver solution that is my discouraged research and development. In my view, I am not sure that whether the implementation of the waiver proposal could bring any desirable outcomes to vaccination to vaccine distribution, as I have just mentioned above. However, such a radical move could potentially disincentivize vaccine development to respond to new COVID-19 variants. For example, the Omicron that's dominating us now. We can take the BioNTech Pfizer as an example. This is the first truly successful application of the mRNA vaccines, but it is little known that the founding couple of BioNTech has started this technology more than 25 years ago and founded their company in 2008. Another thing that we have to think that's the vaccine manufacturer requires significant knowledge of know-how or trade secret, and know-how or trade secret are the high barrier to entry for new manufacturers, and the information is not disclosed in patent applications. Therefore, the waiver proposal is unlikely to force the right holders to share these non-registered IP rights. And based on my research experience, it has been shown that know-how and trade secret is very important, because without them, um, the vaccine manufacturer would be very difficult to manufacture the vaccine safely, and they even don't know what they need to know in order to ensure a safe and a vaccine to be produced. And if we consider IP protection is an issue, how about Moderna pledge not to enforce patent? So any companies can produce Moderna vaccines, but so far no companies took up the offer of Moderna. And we also have the compulsory licensing. And since the beginning of the pandemic, many countries in the world include, developed countries like Canada, like France, like Germany, Australia, and developing countries like Chile, I think that's in Chile and like Indonesia, they have changed their law in order to readily use compulsory licensing once the treatment for COVID-19 is found. But so far, no countries has ever issued a compulsory license yet, and there is no voluntary license request has been made to the best of my knowledge. Thus, is to prove that the manufacturing capacity is one of the reasons why those countries haven't issued any compulsory license for vaccine. And the last point that I would like to highlight, that's a waiving IP might lead to more counterfeit products. And my Indian colleague Vanda, he's already made an excellent speech highlighted on the practical challenges in IP infringement. And in my view, if we dismantle the IP rights protection, so it will allow for more counterfeiting products flowing into countries like Vietnam, where the border controls is not something always easy to be implemented. And the WHO also determined that counterfeiting is facilitated where there is lack of effective intellectual property protection, and therefore removing IP can result in more spread of pharmaceutical crime. And this is not really like the last slide is not really my presentation, but something that I would like my Indian colleagues, if possible, help me to answer the position of the Indian government. So in India, we have the Serum Institute, the world's biggest vaccine makers, and the most significant supplier to COVAX, the scheme that many developing countries rely on to receive vaccine. Vietnam is one of them. But at the same time, the Indian government imposed an export restriction, which in turn hurt those countries badly. At the international front, India proposed to waive the IP protection, but it's very puzzling for me when I found out that at the the national front, there is a document written to the Supreme Court and highlighting the following. Thus, the Indian government say that at this moment, even discussions or mention of exercising governmental power for essential drugs or vaccines that has patent protection could have serious, severe, and unintended adverse consequences, and any exercise of statutory powers can only prove to be counterproductive at this stage. So, for me, it's very difficult to understand the position of the Indian government. And I would like to bring you to my concluding remarks of this presentation. So I argue that intellectual property rights are not barriers to the vaccine productions, and the resources should be directed to solve practical challenges to the input material, to improve partnership, to scaling up manufacturing, to help the regulatory authorities in different countries to speak up their regulatory marketing authorization. And in my view, remove IP does more harm than good. Thank you. Thank you for listening. Okay, how can I stop it now?
Yeah, just a minute. Uh, I'm ending your slide from here.
Yes,
Will it be
please.
fine for you?
Yes, please.
Okay. Thank you very much, Wen, for throwing light on the compulsory licensing and the barriers in the vaccination production. Thank you very much. after hearing all the sessions, we can say that now in the modern world, IP enhances every aspect of our life. If we see each and every product, then it has been protected from different IPs. And IP contributes enormously for our national and the state economy. So here we come with the open floor for anybody who has any question. They can ask any of the three dignitaries which are with us. So I am now over to Forum Ma'am, who is a co-coordinator of the event. She will take on for the open floor. Over to you, Forum Ma'am.
Thank you, ma'am. Good afternoon, everyone, all the viewers and the respected speakers. Dr. Van, first question I would want to ask you, which is from one of the senior faculty members. On a closer look, it appears that IPR stands on contradictions.
Forum Ma'am, just a minute.
Yes, ma'am.
Yes, just a minute.
Sorry,
Yes,
sorry,
yes.
the internet is not good here.
Yeah.
Okay, I'm starting it again, ma'am. Yes. On a closer look, it appears that IPR stands on contradictions. On one hand, it promotes scientific invention and technical diffusion. And on the other hand, countries promoting IPR are creating scientific innovations but are not inclined for diffusion due to tough competition in the market. So, how do you propose to address these contradictions? Please share your reflections on this.
So thanks for your questions. I think your question has touched upon the core value of intellectual property rights, not only in patents, but in on kind of intellectual property rights, even trademark that Sunada has already gave us an excellent presentations. And my point of view is the law has given us some, we call it limitations or exceptions. Let's use India as an example. So your Indian patent law has a very famous section called Section 3D, where you raise the patentable criteria to make it harder for we call it incremental invention to be patentable. So that's a very innovative way to balance to competing interests. An example of India is when it comes to compulsory license, Indian patent law impose the 6 months for the patent holders and the licensee to negotiate for a voluntary license before the other can apply for compulsory license. So in my view, I haven't seen any other countries set a cap of 6 months, and I think that is something very creative. And the creativity of Indian delegates has been proved even in the TRIPS writing, where your Indian delegates had retained the 10 years transitional compulsory licensing. So I think we all have those limitations and exceptions. But at the same time, I think we need to also be aware of the new generation of free trade agreements. So, for example, recently Vietnam concluded their free trade agreements with the UK, with the EU, and we also have multilateral trade agreements. And in those cases, I can see the legislative power of the government to be curtailed to a certain extent when it comes to intellectual property rights. So I think the government should, at least in case of Vietnam, should listen to the expert and need to utilize the policy space. That I think India has set a great example. Just for your information, Indian patent law is one of the subject matter of my research, so that's why I use it quite a lot as an example in this case.
Yeah, I was wondering why how come you know so much about Indian patent law. It's encouraging to know. Thank you.
Yeah, and even in my book I wrote about Indian and Brazilian patent law too.
Okay.
Very nice to know that, ma'am. Sir, I would want to pose the next question to you, sir.
Okay.
Sir, is the abolition of the Intellectual Property Appellate Board, that is the IPAB, a right decision by the government? What are your views regarding the same?
Well, okay, so the abolition per se was sort of required because one of the things that IPAB couldn't achieve is to have a complete forum of technical experts. When it came to, they couldn't hire the right kind of people for years. And so what was happening was that being a tribunal, it was a quasi-judicial body, and it was the problem was that a lot of cases were pending there. Now the appeals from the registry or the trademark or the patent office has had to go through, or the trademark registry had to go to the IPAB for further resolution, and there were a lot of things that were pending on that front. For 6-7 months almost, this happened 2 or 3 times that the IPAB was completely dysfunctional. So the answer to your question is whether it was good or bad. I There is no clear answer to that, but I would say it was required. Something else had to be done. Instead of an IPAB, because a lot of important matters were pending for a long time, and there were since it was a tribunal specifically for intellectual property matters, it had to have technical staff, technical member as a requirement in the committee who used to judge those cases, and that was not there. Now, one of the very, very eminent lawyers who was elevated to the High Court, Delhi High Court, Honorable Justice Pratibha Singh, and she was the one who actually she was a fantastic IP lawyer, and she was the one who now have started this entire functioning of, she's the brain behind having this specialized court, which according to me should have been the case at least 5 years back, because every country that is so diversified in terms of, and that's so innovative, there are so many matters that are filed. We come in the top 10 countries in the world where the applications have been filed by top 10, I guess. Top Yeah, I think so, where the applications have been filed in this country, and many large countries like developed countries like US, Germany, China, Netherlands, Denmark, all these, they're filing applications here. So we had to have a specialized court. So I think yes, a slight delay, but never too late for a good thing to happen.
Thank you so much, sir. Ma'am, Sunanda ma'am, the next question I would want to ask you. Ma'am, what are your views on the national and international preparedness in implementation of intellectual property rights online? It is one of the questions from the viewers.
Okay, if so it's a very broad question. Can you hear me?
Yes, ma'am. Yes, ma'am. You're audible.
Yeah, yeah. Right. So the question as such has multiple dimensions, and because it covers all forms of intellectual property, as in it's a broad question. But insofar as preparedness is concerned, I would say that we are somewhere in the middle. It's like when it all started, when this all IT revolution started and everything, internet was, as in everybody was beginning to get a hang of what internet is all about and what are its implications and what it would mean for our laws and their implementation. uh, we have moved ahead from that juncture, and yes, so by and large it is understood as to what implications and what challenges it poses. But at the same time, we are not fully equipped either. You see, to take care of those challenges, to meet those challenges, because there are a number of if you take, say for instance, copyright law, there are so many changes that the current Copyright Act uh, deserves in order to for it to be properly aligned to the new internet age. You know, so like issuance of copies, physical copies, or whether copies actually includes the e-version of the copies, what is broadcasting. So there are so many issues with, just as I just by way of example I've taken Copyright Act. It Such examples, they are there with each of the main branches of intellectual property, at least in India. So insofar as India is concerned, we are somewhere in the middle. We are just beginning to realize what changes are to be made and how we need to deal with this whole revolution, but we are not there yet. That is what I would say.
Thank you so much, ma'am. Sir, we have one more question for you. So, while dealing with IP infringement cases, how difficult are issues of jurisdiction and applicability of law in cyberspace?
Forum ma'am, can you repeat the question?
Sir, while dealing with IP infringement cases, how
Uh-huh.
difficult are issues of jurisdiction and applicability of law in the cyberspace?
Well, it is now really evolved. So basically, if it comes to cyberspace, it is very difficult to find out where, as I said, where the servers are, and we can't really go to that place. And the offense, if it is committed in a particular jurisdiction, if it is say in Delhi, and if I'm able to purchase an infringing copy from an e-commerce website in Delhi, I am free to file a case here. That was earlier an issue, but the jurisdiction, not only in cyberspace but anywhere, if I am able to purchase or make or receive a copy of an infringing product in a jurisdiction where I am, I can file. I need to prove that yes, I was able to purchase it there. So what we usually do is we try and see if while selecting the forum, we try and see if we can have the metro cities where the courts are more aware of intellectual property, and try and see if we are able to purchase that infringing copy in or the article or the material in the jurisdiction of Delhi, so that we can use the Delhi High Court or the Mumbai High Court or the evolved courts for that matter to fix a jurisdiction. So yeah, it shouldn't be a problem now. But yes, as I said, the problem is not in that. Problem is in how someone does enforce the order of the court, and how can you actually get those infringing copies off the server of the infringer, because the server could be anywhere. But that again, it shouldn't be a problem, because as I said, we can the domain name is well known. You can go to that domain name and find out who has issued that domain name. It's suppose it's godaddy.com, then let godaddy know that we have a court order, and they will restrict that domain name. So yeah, that's what it is.
Thank you, sir. We have one more question for you, sir. If you permit, I may ask it to you.
Yes, please go ahead.
Yeah. This is from one of the students from the senior batch. What are your views on the doctrine of exhaustion and gray markets being semi-legal in many jurisdictions? Whether a proprietor has any reliefs?
Well, it is. I think why don't we have a US view on this? If you want to talk doctrine of exhaustion, about doctrine of exhaustion, I think it all came out from US, right? It was the doctrine that was more of a US kind of a perspective. If Dr. Van wants to talk about this, I can talk about gray markets and semi-legal. Yeah. So. Yeah, so basically, if you talk about gray markets, the there is not one aspect that we are talking about. Gray market is something that is, it's very broad. You have aspects like parallel imports, you have aspects like it may not be essentially trademark or copyright infringement. It may be something else. It may be like parallel imports. You can't. There is a famous case of Samsung, which has happened in India, and there were parallel imports that are happening now. What reliefs do you have? Whether a proprietor has any reliefs? The answer to that is yes. Why not? If suppose there is, as I said, one of the examples I took was the baby products. Now, this is a company that's based in UK or US somewhere, and they had an exclusive license to sell these products. My client had an exclusive license to sell this product in India. Now, when we went for the enforcement, we were told that the products are not infringing. It had come from the real owner, so the rights holder. But to the extent that were they allowed to sell that product in India, the answer was no, because my client had an exclusive right, and by virtue of that license, my client was the owner of that trademark in India. So there are rights. There are I would say reliefs available for the proprietor of the rights holder in India. But yes, may not be 100%, because it is very difficult to sometimes find out whether it was an infringement at all or not, because uh, the license may say that the product will come from the manufacturer and come to India, but the licensing terms somewhere else would be, they may have given that product to say somewhere in Israel, and the Israel company was not restricted to send it further to India. So sometimes things like that happen. So the other person may have taken that import from a valid holder of the rights, and so may not actually amount to infringement per se. But yeah, it's slightly cloudy there, but can be solved.
Thank you so much, sir, for shedding light on this topic. Dr. Van, the next question I would want to pose for you. This is the last question, ma'am, with your permission.
Thank you. So you want me to talk about the
Ma'am, I'm asking you the questions. Yeah.
about the doctrine? Okay.
Yes.
Yes. Recently, South
Forum,
Africa. Yes, sir.
forum, please. I would like to just, if with your permission, now I can, if Van could, or Dr. Van could also throw some light on doctrine of exhaustion, it will be really nice, just for 2 minutes, because that was a part of the question which I did not answer. If it's okay.
Yeah. So I
Sure, sir.
think, yeah, so the doctrine exhaustion, I think it changed from, as Yavadan has mentioned, it changed from one form of IP to another. For example, in the US, why the patent cost, as far as I know, why the IP cost is quite restricted when it's come to trademark. They are a little bit more relaxing when it comes to patent because of different things. In some countries, they treat doctrine of exhaustion differently in different categories. So in general, they are more restricted when it's only come to patent and other essential products. It's more restricted when it comes to trademark because there is the counterfeited products involved. But when it comes to patent, when it comes to medicine, they can allow a government or company to shop around. As far as I know, I think India have the parallel import on patented pharmaceutical, isn't it? Yeah, so I'm not sure how about trademark. Do you run that parallel importing or not, or just only patent?
It is on trademark as well. It is there on trademark as well. All right. So can we, now we can move to the next question.
Forum,
Yes,
you can proceed with the next question.
yes, ma'am. Recently, South Africa has become the first country to issue a patent designating an artificial intelligence tool device for the autonomous bootstrapping of unified sentience, which is the Dabus, as the inventor and the machine's owner as the patent owner. Some experts have labeled it as a mistake or an oversight by the patent office for granting patent to this Dabus. How long shall it take to resolve the controversies surrounding patents and artificial intelligence? What are your inputs on the same, ma'am?
Is this questions for me or?
Yes, ma'am. Even sir can address the question.
Yeah, yes, I think I can quickly address these questions because as offered, we are working on these questions at the moment. In fact, the UK IPO's office, they are calling for public consultation on whether or not we should recognize AI not as a patent owner, but as inventor. So, and based on that, I had the opportunity to do some research. And I would like to mention, although South Africa is the first country to recognize AI as an inventor, however, the decision of South Africa is not highly regarded because they say that the South African patent office did not perform substantive examinations. So the first country, which had a very serious judgment on this issue, that's Australia. So Australia, they have a ruling and they recognize AI as an inventor. However, in the UK and the US, for the same patent applications, the judges said no. So, in my view, at the moment I don't think we can go that far to recognize AI as an inventor, at least from the moral point of view and also legal point of view. So, being an inventor, a patent inventor, a person will be tied to different responsibilities. I'm not sure whether an AI can trade with someone else on their behalf. Can they become a negotiate parties? Can they perform their liabilities? And if there is any defect with the products, I think the company is still the people, the person who is responsible for that. And what happened if that AI generates enough money? Will it be taxed or not? Because if that's an inventor, we have to tax, isn't it? And in some under the for example the UK law, in some cases employees can be entitled to a remuneration from the employers. So how can an AI can be entitled the remuneration? How can they enter a contract with other parties? So for me, it's kind of like the far-fetched futures, and I don't see it happen now. But at the same time, I can understand why other countries want to recognize AI as an inventor to encourage investment, to encourage research and development in that area. But but before this patent application on Dabus, we can see that many industry, many countries already applied AI without the need to recognize AI as an inventor. So in my view, it's a long future, and I don't think we have a super intelligent AI that can replace human beings and that can be treated as a human beings. So my answer is, I am very skeptical about that.
Uh, Thank you so much. Here we end our this session. I request Assistant Professor Forum Pandya to propose the formal vote of thanks.
Thank you, ma'am. It gives me immense pleasure to propose a vote of thanks to the expert speakers of today's national webinar on contemporary challenges of IP law. Respected Dr. Sunanda Bharti ma'am, Dr. Van, and Mr. Vedant Pujari sir, I extend my heartfelt gratitude to you on behalf of GLS University Faculty of Law for being with us today and sharing your expert knowledge on the contemporary issues revolving around the domain of intellectual property law, not only in India but internationally. Your valuable insight into the topic shall definitely help the viewers to enhance their knowledge about the existing challenges in IP law and also the measures to address the same.
What, it got disconnected?
I beg the pardon on behalf of Forum Ma'am, but thank you very much to all the dignitaries and special thanks to Mayuri Ma'am also for always motivating the faculties for going ahead with all such events. Thank you to all the
Am I
viewers
audible?
for it. Yes, Forum Ma'am, you can continue.
There was a technical glitch. I lost my connection. It gives me immense pleasure to propose the vote of thanks to our expert speakers for today's event. Respected Dr. Sunanda Bharti ma'am, Dr. Wen, and Dr. Vedant Pujari sir, I extend my heartfelt gratitude to you on behalf of GLS University Faculty of Law for being with us today and sharing your expert knowledge on the contemporary issues revolving around the domain of intellectual property law, not only in India but internationally. Your valuable insight into the topic shall definitely help the viewers to enhance their knowledge about the existing challenges in IP law and also the measures to address the same. I also take this opportunity to thank our director, madam, who herself is an IP veteran, for her never ending support, without whose support this event would not have been possible. I also thank all my dear colleagues for their direct and indirect support in making this event a success. Thank you so much to all the speakers for today's event. Thank you so much.
Thank you.
Thank you. Namaste.
We look forward to see you on campus.
Oh, sure. Thank you.
Thanks,
Thank you so much.
everyone. Thanks.
Thank you.
Thank you.
Namaste. Thank you.
Namaste. Bye.